Good afternoon, everybody, and welcome to this policy exchange event on rights, more particularly on Nigel Biggar's book, What's Wrong with Rights? It seems that quite a lot is wrong with rights, and Nigel is going to explain that in a few moments. Just a very brief introduction from me. We at Policy Exchange have been very active, obviously, in the field of rights. It's also very timely, given the government's recent announcement of a review of the Human Rights Act, 20 years old this year. But what we are going to do, actually no, what I should do, well, most of you probably haven't had a chance to see Nigel's book. It is well worth a read, published by Oxford University Press. I might just briefly, it is a critique of rights fundamentalism. It's lots of other things too. I might just very briefly sum it up in a few questions that whoever wrote the invitation to this event listed. I think it gives you a little bit of an insight into what the book is about. So here are 5 or 6 questions that it raises. Are natural rights nonsense on stilts, as Jeremy Bentham memorably put it? Must the very notion of a right be individualistic, subverting the common good? Should the right against torture be absolute, even though the heavens fall? Are human rights universal or merely expressions of Western neo-imperial arrogance? Should judicial oligarchies, rather than legislatures, decide controversial ethical issues by inventing novel rights? Ought human rights advocates learn greater sympathy for the dilemmas facing those burdened with government? That gives you a flavour of some of the very big questions that Nigel's book is raising and answering. Anyway, we have a very distinguished panel of respondents, and how we're going to arrange this is that Nigel is going to speak for 9 or 10 minutes, and then the respondents are going to respond in, I think, 5-7 minutes or so. We will then have I think a brief discussion between the people on the panel and Nigel, and then I'll open it up to you people out there for comments and questions. The panel, by the way, consists of, you can probably see some of them, the panel consists of Lord Sumption, former Justice of the Supreme Court and recent Reith lecturer, John Larkin, QC, former Attorney General for Northern Ireland, and we're expecting, although I think she's still not with us, Baroness O'Neill of Biggar, a former chair of the Equality and Human Rights Commission, and a philosopher who's written extensively about rights. So we, in the hope that Honora is going to join us a bit later in the process, why don't you, Nigel, kick off and give us an overview of your thesis?
David, thanks very much, and thanks to Policy Exchange for hosting this launch, and especially to Richard Eakins, who heads the Judicial Power Project here. So first of all, some brief good news. The good news is that there's much that's right about legal rights. Legal rights are important social institutions for securing liberties and benefits we all value. But there are at least 4 things wrong with the way we tend to talk about rights. One is to suppose that a basic human need automatically generates a moral right to have it met. So, since being sufficiently well-fed is a human need, there must be a moral right to it. I don't think so. A right gives the holder of a right leverage through social institutions, not least law. Where there are no institutions to determine who owes the hungry how much, there is no right. There is, of course, a duty upon those who can to help as best they can, but the hungry have no right. In general, I think it best not to talk of moral rights at all. A second problem with a lot of rights talk is the failure to reckon seriously with the dependence of legal rights on social conditions. So, for example, in the early 2000s, human rights advocates criticized the Rwandan government for failing to secure the right to a fair trial of those accused of genocide by providing them with legal counsel. Yet at that time, most Rwandan lawyers had either been slaughtered or had fled, and no one was offering to pay for the importation of sufficient substitutes. Meanwhile, unlike rights advocates, government ministers had to decide how much longer to keep the 130,000 suspects crammed into prisons designed for 12,000, where many of them were dying. The government decided on a form of trial more efficient in processing cases, with some safeguards against an unfair trial, but not legal counsel for the defense. Yet that did not stop rights advocates complaining, with the result that government ministers ceased to listen. The stubborn unrealism of rights advocacy had drained it of credibility. The same problem sometimes arises among judges. Thanks to Policy Exchange's report, The Fog of Law, I came to read the European Court of Human Rights 2011 judgment in the case of Al-Skani. This concerned the 2003 killing of Iraqi civilians in Basra by British soldiers and the UK's decision not to conduct maximally independent investigations into their deaths. The issue was whether Article 2, which affirms the right to life under the European Convention, should apply outside the territory of the state's party. The UK's Court of Appeal, the Law Lords, identified the decisive criterion as effective control. If a state party had effective control of overseas territory, then the rights should apply. However, the court judged that since the situation in Basra was verging on anarchy, whatever the UK's formal responsibility, it had no effective control. Therefore, the maximally independent and impartial kind of police investigation expected in peacetime Europe was not reasonable to expect in semi-anarchical Basra. The Strasbourg court quoted the UK judgments at length, acknowledged implicitly the criterion of effective control, but then without explanation ignored it in favour of formal control and authority, and prescribed a maximally independent investigation in anarchical Basra. One clue to the failure of this judgment to reckon with political reality lies in the concurring opinion of the Maltese judge Giovanni Bonello. In his opinion, Bonello exhorted the court, and I quote, to stop fashioning doctrines which somehow seem to accommodate the facts, but rather to appraise the facts against the immutable principles of the sanctity of human rights. It is the mission of the European Court to achieve the supremacy of the rule of human rights law, end of quote, in proud disregard of the facts on the ground. In his 2017 book, Human Rights and Political Wrongs, a fruit of Policy Exchange's Judicial Power Project, Sir Noel Malcolm found the quality of the Strasbourg Court's legal reasoning generally wanting, and concluded that the UK should leave the European Convention. If the rights fundamentalism I discern in the Al-Skani judgment characterises Strasbourg's jurisprudence as a whole, then that would be another reason for leaving it. But only if rights fundamentalism stops on the far side of the English Channel, because if it already infects the UK judiciary, then leaving Strasbourg won't solve that problem. In addition to talk about moral rights and fundamentalist talk that ignores social realities, a third problem is abstraction. In the case of Carter in 2015, the Supreme Court of Canada declared the refusal of Canadian law to permit assisted suicide a violation of Section 7 of the Canadian Charter of Rights and Freedoms. This asserts the right to liberty, except in accordance with the principles of fundamental justice. Implied here is a presumption in favour of the abstract liberty of the individual, which places the burden of proof on any public good concern that would limit it. It also hands to judges the authority to decide when that proof is sufficient. I have three objections to this. First, there is no moral priority of the liberty of the individual. We are all born into social duties. Second, case-focused courts are less well equipped than parliaments to make a comprehensive judgment about the social risks and costs of a right, a point thoroughly argued by the 2018 book edited by Richard Eakins and called Legislated Rights. Third, a judicial decision on a highly controversial public moral issue which overrides, as it did in Canada, the recently confirmed will of Parliament, involves judges assuming the role of makers of law and not merely interpreters of it. And since judges are not elected, it risks the democratic legitimacy of the law they make. Fourth and finally, there is the problem of the dominance of rights talk. Take the legal right to free speech. While this is vital to a liberal society, it can be abused. That's to say, we can exercise our legal freedom in immoral ways. We can, within the law, exercise our right to free speech by being unfair, by being uncharitable, even by being sadistically provocative. We can legally, but we shouldn't morally. Even if the law permits us to spit on other people's sacred cows just for the hell of it, we shouldn't morally. So while I affirm the legal right of the Charlie Hebdo journalists to publish cartoons mocking the Prophet Muhammad, and while I abhor their murders in January 2015, I do doubt the morality of the cartoons because I fail to see what good they sought to achieve. But whatever you think about my views on Charlie Hebdo, and many people don't agree with them, my general point is this: that in addition to rights, we also need citizens who exercise their rights well rather than badly, who have the qualities of character, the virtues that enable them to do what moral duty obliges. Because otherwise, the widespread abuse of rights will generate pressure to restrict them or withdraw them altogether. So rights talk is not enough, not even for rights. We also need duty talk and virtue talk. That's the gist of my book. Thanks.
Well, thank you very much, Nigel. I think we kind of half have Onora, but no, we do have Onora. Hello.
Yes, hello. I've been here all the time. You just couldn't see me.
Oh, okay, good. In that case, are you happy to respond? I'm sure Lord Sumption, if you'd like to go further down.
Whatever order you have us in, David.
Okay. By the way, I forgot to introduce myself earlier. My name is David Goodhart, and I'm head of the demography unit here at Policy Exchange. And I've actually just also been appointed a commissioner of the Equality and Human Rights Commission that Onora used to head. Well, so why don't you go ahead and let's stick to the original order, Onora.
Thank you, David. Well, very nice to see you all. I'm sorry to have been looking over your shoulder, as it were. I don't understand every version of Zoom. I think I agree with Nigel in many ways, and that will surprise you because I'm quite in favor of very many different human rights. But he's surely right about rights fundamentalism. And I think his argument against the proliferation of rights is spot on. As it seems to me, it's quite difficult to understand how we've got to where we are. So I thought what I'd do in my 5 minutes is to give a little historical sketch of what I think the story may be. The present landscape is quite striking and very different from what it was a decade ago. A decade ago, I think you'd have met a lot of enthusiasm for rights and sporadic criticism. But I have noticed that among my crowd, the political philosophers, there is a very marked division between those who think human rights are moral rights, and if you haven't got the arguments for that, then you can't go with them, and those who think that they are political, or as we tend to say in my tribe, merely political, meaning that the justification is not sufficient to show that they have global reach, that they are the contingent edicts of particular legislatures, jurisdictions, and so on. Now, I think the questions that have interested me a bit and what's led me to agree with Nigel on certain matters is why was there such enthusiasm at one time, quite a recent time, and why did it ebb? What happened? And I think to explain the enthusiasm is harder than it may seem to most who share that enthusiasm. But here goes. As I see it, European discussions of ethics and politics, of ethics and justice, have been centered on the question, what ought we do? From Cicero until the early 20th century. That was the question. And of course, the answer was put in terms of duties. It wasn't the case that people asked, what ought I get or what ought we receive? The recipient's question. Of course, there was early queries of duty. You can think of perhaps not very early Nietzsche in the 19th century. But I believe that the crucial moment for disgust with duty is the First War, with people feeling that they have been betrayed and that duty is terrible. The ethics of patriotic duty, of course, led the way. And the consequence was that many people then endorsed a fairly unashamed form of ethical subjectivism. Subjectivism can be made to sound pretty grand. Think of Yeats, nor law nor duty bade me fight, nor public men nor cheering crowds. A lonely impulse of delight drove me to the clouds. Impulses of delight can get people doing some pretty dreadful things. But subjectivism can also be made to sound rigorous, let's say pseudo-rigorous. Think of logical positivism. And it can be made to sound absurd. And this is actually my favorite comment on subjectivism. It's Groucho Marx. What he said was, yes, I have some principles, and if you don't like them, I have some others. And that is, I think, the reason why subjectivism is not a terribly convincing position. But it's extremely popular. You will all have noticed people, for example, talking about my values, his values, her values, British values, as though the possession of a value was what made it valuable. If that's all we can say, I think we were bankrupt. Let me go back then to World War II, because I think this was when the tide turned. It's no accident that the great human rights documents come at the end of World War II. At a moment of crisis, subjectivism isn't really very helpful. And both the Universal Declaration and the European Convention are early post-war, but of course thought about already during the war. And in some ways they've served quite well, but they're open to serious objections. And I share Nigel's sense that it is unfortunate when people think that they can add a right here, have a larger right there, have a less constraining right there. And what do I think we need to do? Well, I would say the first thing is to realize you don't get any rights for anybody unless there are counterpart duties. We can't have rights without ensuring that action is feasible. Again, I agree with Nigel for those charged with the relevant duties. If we think there's more than one right, then that right, as all lawyers know, that right cannot be unqualified. And if rights must be qualified, then both judicial reasoning and cultural interpretation, which I know Nigel favours, are indispensable. Finally, it certainly isn't a good idea to try to add rights, unless, of course, one thinks that all existing rights should be further qualified. Thank you.
Thank you, Nora. It's great to have Yeats and Groucho Marx and Nietzsche all wrapped up in one brief intervention. Could we have Lord Sumption now?
Certainly. I'm going to say something relatively brief about what I regard as important about Nigel Biggar's book. And if I can add to the literary catalogue, Voltaire said in one of his works, I'm afraid I forget which one, a report is spread that there exists in some distant country a giant as big as a mountain. Immediately people start venomously disputing the length of its nose or the breadth of its fingers. But if somebody then turns up and doubts the existence of this giant at all, everyone turns around and simultaneously attacks him. The moral of this story is that shared assumptions are intrinsically unsafe and quite likely to be wrong. Because they are shared and profoundly shared, they are not tested and not challenged. Nigel Biggar is the bold skeptic in Voltaire's parable, who has challenged one of the most pervasive of the shared assumptions of our time. And that is the view that there are rights which are not the creation of human institutions, but are inherent in our humanity. It follows from this that they are objectively true, universally, and eternally. This is not a new idea. It exists in Roman law, it exists in Christian theology, but in its modern form, I would date it to the Second rather than the First World War, because the problem which people faced at the end of the Second World War is that many of the unspeakable wickednesses of the Nazi government had been perfectly and impeccably lawful, at any rate within so far as they occurred in Germany. The Nazis had gone to great trouble to ensure that everything was enshrined in rules, laws, and regulations, so that it was necessary to identify some superior source of law by which they could be judged and condemned and in many cases executed. That is a more difficult notion to apply in a democracy such as Nazi Germany wasn't. Because if rights are inherent in our humanity, then they exist independently of political choice, independently of any institutional setup. Public consent is irrelevant, and yet precisely because rights are a claim against society, then consent can never be irrelevant. But the effect of rights fundamentalism is that these rights are identified not by reference to the constitutions or the institutional setup of society, but by a process of abstract reasoning by officials designated for that task, namely judges. Now, Nigel Biggar's book is not primarily a work of political or constitutional analysis. It's a work of intellectual history and ethical analysis. But of course, fundamentalism about rights has a very significant political importance because it is essentially subversive. It creates a body, or seeks to create a body of principle independent of the institutions of a society and in principle capable of prevailing over them. That is the point of the illustration on the front jacket of Nigel Biggar's book, which shows the execution of Louis XVI in the course of the French Revolution. In modern terms, it means that there are rights which prevail over the established legal norms which societies set for themselves by a political process. This process may well get worse in the following years if we are not careful, because we are on the verge, I think, of a move into positive rights, a right to a minimum standard of living, to a minimum standard of health provision, to a minimum standard of educational provision. All of these things have radical implications for perhaps the most fundamental feature of any constitutional setup, namely the arrangements for deciding how much money you are going to take from people and what they're going to be spent on. It seems to me that once one moves into the sphere of positive rights and gives legal effect to them, one will be seeing the end of any kind of reasonable democratic accountability. Now, Nigel Biggar is not against rights as such, but he makes what seems to me to be an extremely valuable distinction between moral rights and legal rights, moral rights not requiring the same degree of definition and being possibly more equivocal. The rigor and intellectual honesty with which this case is made is, I think, impressive. It will, I fear, lead him to some places where he will find that he has very few traveling companions. In particular, many people will take issue with his highly qualified view about the morality of torture and his explanation of the legal prohibition of torture, which is essentially that it is a pragmatic principle rather than an exclusively moral one. But that is because we all tend to confuse moral principle with emotional response, and that means that we do not often examine the intellectual foundations of some of our most deeply held views. It is good for us, therefore, to read a rich and challenging analysis such as Nigel Biggar has offered us.
Thank you very much, Lord Sumption. Now before I pass over to John Larkin, just a reminder that after John has spoken and perhaps Nigel has then had a brief chance to come back at the respondents' points, we will open it up. So if you want to ask a question, raise your virtual hand. I think there is something at the bottom of your screens that allows you to do that, just a reminder of that. Okay, over to you, John.
Thanks, David. Well, I'm tempted simply to say amen to Lord Sumption's words. This is a hugely important book with an admittedly provocative title. While a direct answer to the question can be given, I think, in one word, there's nothing wrong with rights. The discussion that the book inspires and informs will take a little bit longer. One of the worst faults in a reviewer is, of course, discussing a book other than the book, in fact, written by the author. I hope to avoid this, but I can't help speculating about a different title. There is nothing wrong with rights, but much to be condemned in the contemporary discourse of rights, not least because it can lead to an impoverishment of policy development, political choice, and I think at its worst, an overblown discourse of rights can contribute to an abuse of rights. Professor Biggar's book is an attack over many fronts on the phenomenon that the French happily have an expression for, but we don't, droit de l'hommisme. And Part of the reason for that may be that we suffer much more from it than do the French. Part of the problem with rights discourse and the application of rights is a confusion about the foundation of rights. In the sphere of international human rights law, there is observable a species of what one can, I think, call human rights positivism, by which rights exist by virtue of being found in an international instrument or, as very frequently now, in the infusion of various international committees. For my part, I tend to blame, at least in part, Jacques Maritain for this, and could have wished Professor Biggar to be sterner with him, because in his second UNESCO conference, Maritain, as well as pointing to the pragmatic commonality of agreement about how rights work in practice, went on to try to terribly opaque language from Maritain, who's usually agree with him or not clear about what he's saying, talked about something emerging from the consciousness of free peoples to constitute, grosso modo, his expression, a sort of common residue, a sort of unwritten common law. Well, I think that that's simply a form of rhetorical hideout for the absence of foundational consensus. Burke, who naturally, as an Irishman, I'm very attached to, I think got it right. And he and Nigel Biggar are, I think, at one in saying that there is a natural law, there is a natural moral order. And one of the great rhetorical illustrations of that comes from Burke during the impeachment of Warren Hastings, when he rejects the founded by Hastings that there are really different standards of morality. But where I think Professor Biggar and Burke part company, and I side with Burke, is that Burke is, in the abstract, a believer in natural rights, contrary to Professor Biggar's conclusion, page 131 of his book. And Burke says this, far am I from denying in theory, full as far is my heart from withholding in practice the real rights of men. In denying their false claims of right, I do not mean to injure those which are real, and as such as their pretended rights would totally destroy. If civil society be made for the advantage of man, all the advantages for which it is made become his right. Burke then goes on to say, of course, is that these metaphysical rights, he uses the physical image of light, are refracted and then take their color and concrete form in concrete individual society. And Burke's question that he asks in the reflections remains relevant. What is the use of discussing a man's abstract right to food or to medicine? The question is upon the method of procuring and administering them. In that deliberation, I shall always advise to call on either the farmer and the physician rather than the professor of metaphysics. And I think Burke reminds us that a preoccupation with or an insistence on rights may disrupt the role of a healthy political and social culture and the practical outcomes that human beings outside the academy have greater importance than abstractions. And in this vein, a deliberative assembly is more often than not a better place to work out practical solutions than a court. And I think, again, another often overlooked natural lawyer, William Blackstone, got this right when he chose to regard members of Parliament as the guardians of the Constitution rather than courts.
Thank you, John. Now, Nigel, would you like to briefly respond to some of these points? To perhaps
yes,
I'll
make it brief because I don't want to take all the time up. So if I can just respond to one point that each of my interlocutors have made, and first of all, let me thank them for taking the time to take part in this discussion. First of all, Honora gives an explanation as to why it is that rights talk has become so dominant among us. The spread of moral subjectivism, perhaps a notion that morality is culturally relative, a lack of confidence in morality we share. So we resort to law, we resort to rights rather than morality. I think that's a correct analysis of how we got here. But I nevertheless discern a sign of hope in that although we are often reticent to talk about things like duty and virtue, we often do refer to them in oblique fashion, because we know that social life cannot survive without people doing their duty within the law and without exercising certain virtues. So I think, in fact, although we're reticent and tongue-tied over common morality, I think, in fact, we share a whole lot more in common than we realize. And part of the solution, I think, is we need to own up to what we know but dare not say, and then have a conversation about what are the virtues we think we ought to be fostering. Then, responding to Jonathan Sumption, he's quite right to say that in the end I decide that it's best not to talk about moral rights. Let me make clear why that is. I do believe in common morality or natural morality. I do believe there are universal moral principles that nevertheless find different expressions in different cultures. But I do think it unwise to talk about moral rights for this reason. I understand a right to be a social institution that gives a moral claim extra force. It gives it leverage through police, through courts, through law. Where there are no social institutions, the claim doesn't have that force and security. Therefore, to talk about moral rights that are not legal is misleading in that sense, because moral rights don't have that security. If I have a moral claim against someone, then it may be that my claim has purchase on their conscience, but I can't depend on it. So it's an insecure claim. A right, being legal, having social backing, has a characteristic force. But I do believe in natural common morality, because I do believe that legal rights need justification, and they can't justify themselves simply in legal terms. They have to reach for moral terms in which to justify themselves. And one important way in which legal rights need to justify themselves is in terms of prudence, because legal rights do have costs and they do involve more or less risk, and prudence is a moral virtue. Then turning to John Larkin's comments, I mean, his alternative title is far more accurate. It's just not very zippy. So he's right to say that I don't, there's nothing wrong with rights as such, with legal rights. But the reason I chose the title I did, What's Wrong with Rights, is that there are some people, there are some quite well-known philosophers who think that talking about rights at all is problematic, because they think that rights talk, even legal rights, are necessarily individualistic and corrosive of the common good. And you find that in certainly among some Catholic philosophers, Alistair MacIntyre most famously. And I don't agree with that. I think that there's no problem with legal rights as such. As for Burke, John's quite right. I knew I liked Burke before I wrote this book. I know I like him even more having written it. And in most respects, I'm quite Burkean. And it is true that Burke did believe in natural moral rights, although my own reading is not terribly strongly. He affirmed natural moral rights, but was very sensitive to the ways in which appeal to natural rights could lead to imprudent, revolutionary political action. Hence the picture on the cover of my book. And he was very nervous about abstract rights. But John's right. He did talk about natural rights. I would prefer to talk about natural morality, not natural rights, for the reason I've explained earlier. I'll leave my comments there.
Good. Okay, thank you, Nigel. Now, just another reminder that if you want to ask a question or make a comment, can you raise your virtual hand? I think we do have a few questions in the pipeline, but can I just kick off and perhaps bring it back down to earth a little bit and ask how you would like, with the principles that you've laid out in your book, with your critique of rights, what would you like to see coming out of the government's review of the Human Rights Act?
That's a fair question. It's not one I'm consider myself expert in. I don't know is the answer, David. But I do have a general suspicion, as I was talking to Lord Sumption earlier, about abstract rights and about charters of rights that give a wide degree of discretion to judges, because I do think that rights often depend on the rightness of the propriety of granting a right, such as to assisted suicide, depends on a judgment about all sorts of social risks and costs. And I think that Parliament is best placed to weigh up those rights and costs than small groups of judges. So I'm generally suspicious of lists of rights, whether they're British or any other lists. I think beyond that, I'm not really equipped to answer your question.
Okay, fair enough. Now we've got a question from Alexander Carlyle. Would you like to make your point, put your question? You'll have to unmute.
Yeah, thank you very much. In a recent article, David Selborne described the atrophy of shared citizenship in Britain, and he cited as causes grotesque and growing inequalities, a concept of citizenship increasingly defined merely by the rights to which it gives access, and the dispersal of so much of the community into predatory private hands, as he put it. Do you agree that he may have a point, and that we should perhaps be discussing the reciprocal duties which citizens should have alongside rights in order to debug the fear, often unjustified, of the consequences of providing chartered rights?
I certainly think that we need to become less reticent about talking about duties. Of course, all rights imply duties. My right implies your duties. So the concept of a right is implicit in the concept of a duty. However, there are other duties. When I talked about free speech, I wasn't talking about duties that follow from a right. I was talking about duties that a right holder has about using a right well or badly. So I certainly think we need to become more upfront about talking about rights and indeed virtues. I don't think the concepts are foreign to us, but we do have a strange reticence, perhaps for the reasons that Honora O'Neill has described in talking about these things. But we don't in fact function without them, and we need therefore to become rather more candid in owning them, and then have an adult discussion about which ones we can endorse in common.
Good, thanks. Anybody else want to chip in on that one, or shall we move on to the next question? Or perhaps the other panelists could say something in response to some of these questions at the end. We've got another 15 minutes or so. Let me ask the next questioner, who is Elora Finley, Baroness. Oh, sorry, Baroness Finley. Yeah.
Yeah, thank you very much indeed. Thank you for an absolutely fascinating debate today, and particularly for also having a Nora O'Neill on there. I was reminded of the way that she explains with amazing clarity relational autonomy. And I wondered how you view the rights of one person in relation to the ability of another to have a conscientious objection or an alternative view, whereby the rights of one may result in deep offence caused to another, and at what point do the rights of the other person end in relation to their duties, particularly when, for example, in healthcare, they may be tied up with the essence of their job, so that it becomes a lot more difficult for them to say no, and at what point should they be dismissed. And I was thinking of some of the cases that there have been in recent years where there was some midwives dismissed in Scotland. That was an extreme example, but there's also the question now in Canada. You raised assisted suicide and euthanasia, Professor Biggar, but where there some hospices are being forced because they will lose their funding if they don't participate in that programme. So I value your comments, really, where rights collide with conscience.
Yes, thank you. I suppose my initial thought is that in a liberal society, particularly, let's take the case of assisted suicide, which is highly controversial. I've thought about it myself. On balance, I'm conservative. I think it would be unwise to make it legal to have medical professionals assist in the suicide of patients who want to die. But I recognise there are arguments on both sides of the fence on that one. If we were to make it legal for patients to ask medical professionals to help them commit suicide, I certainly think the law should recognise that this is highly controversial, even if we make a decision as a society to create such a right, and that the consciences of those who feel unable to participate should be respected. That would be a liberal thing to do. I suppose one of the difficulties in creating a right to assisted suicide, it does imply that the medical professionals have a duty to meet it. Well, suppose the medical professional has a conscientious objection to it. They should be permitted to stand back. But the fact of a right does imply that someone has a duty, and it rather assumes that that most medical professionals that are relevant to this kind of business won't have an objection. So before we create a right to assisted suicide, we need to think about that. And what are we going to do in the case of people who really have strong moral objections to assisted suicide? That's the best I can do, Laura. Do you have any? Have I answered your question?
And does anyone else on the panel want to chip in on that one?
Well, only to say that the dilemmas which you foresee in a world where assisted suicide was legal are dilemmas which we have already encountered in the context of people who have conscientious objections to abortion. This is not a new issue, though it is obviously a very important one.
And in the case of abortion, is it the case that medical professionals are allowed to withhold themselves from that without penalty?
By and large, yes, but there have been some problems, particularly when it comes to people who are not involved in the actual administration of an abortion, but in the management of clinics where some people will participate in an abortion, others will not.
Okay, now we've got technically complicated. We have a question from Vernon Bogdanor, but for some reason he can't ask it himself, so I'm going to read it out. And the question is this: why is Parliament better placed to adjudicate on questions of rights when many holders of rights belong to small and perhaps unpopular minorities who have no leverage in the electoral or political process, e.g. asylum seekers? The other 27 members of the EU empower judges through the European Charter to disapply legislation conflicting with fundamental rights. Are MPs so much more sensitive to human rights than the legislators of other EU member states that they can be entrusted with this important function?
That's a good question, and it's one I haven't thought through very carefully. The advantage of Parliament when considering whether to grant a right, when that right involves certain social risks and costs, is that Parliament can commission inquiries that take a broad view of the issue. Courts, on the other hand, are focused necessarily, myopically, on the case before them. And so their capacity to take wide soundings is more limited. So that is the general advantage of Parliament. I do accept that there may be certain fundamental rights that courts should guard and restrict where parliaments may go. But in general, I think those should be very limited, and that Parliament is the best place to consider the broad concerns and also to secure widespread consent or assent to the conclusion, because if Parliament makes a decision about a right that I disagree with, at least I know that my voice will have been heard through my representatives. I also know I have the chance, perhaps, to use political means to reverse it. Whereas if a court decides it, I have no recourse at all against the decision. And I'm more likely to resent the decision if it's one I don't like. So in general, I think Parliament is the best place to decide controversial issues that are involved in the decision to grant a right or not. But
I make one comment on that.
Yep.
I think it's instructive that in the United States, where the abortion issues were decided by courts, we have had decades of sporadic hostility, including blowing up, sometimes leading to deaths, of abortion clinics or hospitals where it's done. A parliamentary process served rather better here and in many other countries.
May I add this? I think that the implication of the question is that when you ask yourself whether courts or Parliament do a better job, the implication seems to be that one is simply asking oneself the pragmatic question, who will do the job best? I don't think that that is the fundamental question at all. The basic function of any constitutional setup is to enable us to live together in peace, notwithstanding that we differ profoundly in our opinions and in our interests. the fundamental reason why Parliament is a better place to do that is that many disputes about rights are not actually disputes between the state and the citizen. They are disputes between different groups of citizens as to what the collective decision about a particular problem ought to be. And it seems to me that if you are going to resolve a dispute between different groups of citizens, you can only do that in a democracy by resorting to a deliberative process in which those views are represented, and Parliament is clearly designed to achieve that, whereas the courts are not. And I think that Honora's point about abortion in the United States is very pertinent in that context. We are talking really about legitimacy, and the law needs legitimacy. The courts cannot provide legitimacy without some kind of institutional process of reconciliation of different views, and Parliament is the institution which is best placed to achieve that. It very often does it very badly, but it does it less badly than anyone else.
So if I could ask you, Vernon Bognanor's question was about, I think, the protection of a minority. So what's your answer to him on that point?
I think that minorities, I mean, asylum seekers, have the disadvantage that they are not citizens and not therefore participants in the democratic process. But it seems to me that minorities are likely, in most cases, to have a stake and an influence on the outcome of the parliamentary process. In this country, minorities, particularly ethnic minorities, are an extremely important constituency which political parties find it in their interest to bid for their support. And that is how, in practice, it happens. Now, I agree you can have a situation in which minorities are deliberately excluded because the rigidity of those who represent majority groups enables them to be kept out of any decision-making process. Thus, for example, the small number of Arab representatives in the Knesset in Israel have effectively no interest, because the common view of all those who represent non-Arab parties is to combine to leave them out of the discussion. I think such situations are very rare, and I don't see that there's any likelihood of that happening in the foreseeable future in this country.
Okay, well, look, we're getting very close to the end now, but and of course, as is usually the case, we now have a very, very long list of questions, but I will just take two very quick ones. So Alexandra Easton, and then David Potter. Perhaps ask your questions or make your points one after the other. Alexandra going first, and then a quick response from Nigel, and then I will go home and have a cup of tea. I know we're at home already, aren't we? Alexandra?
Yeah. Good afternoon. Can you hear me?
Yeah.
Yes. Thank you very much, Professor Biggar, for your most interesting talk. I will quickly ask the question I originally asked as a teenager. If the Human Rights Act had been originally named the Universal Declaration of Human Responsibilities, thus the ensuing duties spelled out, would the present situation have been any better?
David Potter, are you there? No. David Potter? No?
Yeah, I'm here. Yes. Am I now unmuted?
Yeah, we can hear you now.
My question was very simple, was from a layman's point of view. Could anybody on the panel give 2 or 3 very simple examples of things that might be improvements by amending the Human Rights Acts?
Okay, good. Well, Nigel and anybody else on the panel who wants to chip in, and then we really must draw it to a close.
Right, I shall toss the second question to Lord Sumption and John Larkin nor O'Neill. I shall leave them to think about that while I answer the first one. Would it have made a difference if the word responsibilities had appeared in the Human Rights Act? Not the kind of difference I want. I mean, of course, rights imply someone else's duties, so we've got that. But what I'm concerned about are the other duties not implied by rights. As I said, a right to free speech implies that you have to listen to me say things that you don't like to hear. But as a right holder, I have a duty to speak fairly and not to insult you gratuitously, etc. Yes, speaking up the duties and responsibilities that are entailed by rights is good, but it still leaves out other duties that are not entailed by rights. It also leaves out the very important matter of the virtues we need as citizens and who's going to foster them. So the answer to your question, I'm afraid, is no, that wouldn't do the job.
Okay, a final word from anybody else on the panel?
Well, Nigel suggested that I should deal with the second point. I will do that very briefly. The biggest single improvement that could be made in the human rights regime would be to remove the right of courts to extrapolate from the defined rights contained in the Convention into new rights not contained in the Convention, but which are thought to be in the same spirit or to be necessary for the purpose of updating it or giving general effect to the same frame of mind if we were to remake the Convention now. That's a legislative process. Courts should have nothing to do with it, and it seems to me that that is the way in which we could produce the most striking improvements.
Can I,
John Larkin, yeah.
Can I add to the shopping list in relation to the Human Rights Act? Firstly, and in no particular order, the protection currently given to acts of Parliament, primary legislation, not all primary legislation, but most, should be extended to subordinate legislation. Secondly, it should be made clear that Section 4 and the Declaration of Incompatibility should not be available save to those who have the requisite standing for the purposes of Section 6 and Section 7 of the Human Rights Act. The commencement should be altered to make it clear that Article 2 of the Convention cannot be invoked with respect to cases arising before the 2nd of October 2000. And those are all pretty straightforward legislative fixes. And I suppose my equivalent of Lord Sumption's rather more ambitious proposed change would be to make it clear that the task of courts when dealing with a convention claim is confined to determining whether or not the qualified right is, the interference of the qualified right is in accordance with law. If the issue of proportionality has been addressed by a domestic public body, like the council, dissolved administration, Parliament itself, or by central government, then the call on proportionality made by the democratically accountable institution shouldn't be capable of being called into question by domestic court.
Good. Well, that's a very good and very specific note to end on. It just remains, I think, to say thank you to Nigel and the three panelists. I'm afraid you're just going to imagine noisy applause coming from all the people out there. And perhaps, I mean, just a reminder that this meeting has been about Nigel's book, What's Wrong with Rights. It would make, I'm sure, a very good Christmas present for the more philosophically minded of your friends and relatives. Anyway, well, thank you all very much for attending, and I now draw this meeting to a close. Bye-bye, everyone.